Hi, everyone. Welcome. So, today I am going to be answering your questions. So, if you have questions for me, immigration law, US immigration law related, please go ahead and put them in the comments because I will be responding to those. I am also going to be responding to questions that I got before this. So, if you have questions, put them in the comments. If you're watching on the replay and you're like, oh, I have questions, I missed this live session, go ahead and put it in the comments. I will be responding to you, and I will most likely be doing a video response as well. So go ahead and ask me your questions. I am a U.S. immigration attorney. I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. So if you want to join my community of informed immigrants, please feel free to subscribe, like, share, all the good stuff. And if you want to know if you or your family qualify for a green card or citizenship, feel free to reach out. You can schedule a strategy session by going to my website, lilylegal.com, or by calling my office at 508 443 1788. All right, let's jump right in because I have questions. Right. I have so many questions here. So I'm going to try to get through as many of them as I can. Like I said, if you're watching this live, feel free. Feel free to put your questions in the comments because I will be responding to those live. Okay. And then if you're watching in the replay, like I said, put your questions in the comments as well because I will go back and respond to your comments and most likely add it to my next Ask Me Anything video. Okay. All right. Let's get into it. All right. So let's start with this question. So this question came from my video that the title is Can a Step Parent File a Green Card Petition for a Stepchild? So that's the video this question came from. It asks, what forms are used for two children 9 years old twins? Well, if you are the step parent, right, and you're filing for the children, you will need an I-130. If they are outside of the US, you will start with the I-130, wait for that to be approved, move on to the embassy stage where you will do the DS-260 and affidavit of support if required, right? If they are in the US and they came in with a visa, you can do an I-130 and an I-485 at the same time. That way they're able to apply and get their green card. So again, what forms do you need for two children? As their step parent filing for them, you will need an I-130. And then if they are physically in the US and came in with a visa, you can then also add the I-485, which is the green card application. If they are outside of the US, you file the I-130, wait for that to be approved, then you move on to the embassy stage where you will do the DS-260 and affidavit of support if required. And then those are the forms, right? And then they go to their interview, get approved, come to the US. All right. So those are the forms that you would need for your stepchildren, whether they're in the US or outside of the US. All right. So the next question that I have from a viewer is from my red flags to avoid in a marriage-based immigration case. So the question is, if both names are on the lease, but not, because not everybody can change their license when they move. So this basically saying you move in with your spouse after you two get married, you haven't updated your license, but both your names are on the lease, you live together. Do you actually need to go and change your address on your license so that you have the license that has your current address on it just on the face? Well, no, you don't have to, but most DMVs, RMVs require you to update your address with them. So you should do that. However, you don't need to get a new license. Most of the time, they wouldn't have you get a new license. So that is fine, right? This question is actually hidden on something that I want to cover with you all. If you are moving in with your spouse, if you're moving in with your spouse and you need to renew your license after you have already moved in with your spouse, the only address acceptable to be as your address on your license is your home address where you live with your spouse, right? So although there's a red flag, the red flag with the license not having your home address on it comes when you renew your license or you get your license after you're already married, after you're already moved in together, but it still has your old address. That's a red flag. Okay, that is the red flag. However, if let's say you got your license 2 years ago, you got married today, you move in with your spouse tomorrow, is USCIS going to penalize you because your license hasn't expired yet and you don't need to renew it? So it still has your old address on it? No, right? No, because that's understandable. However, if your license has already expired and you need to renew it today and you're already living with your spouse today, your home address where you live with your spouse needs to be on that license. If it's not and it's a different address than your home address, that is the red flag. So just keep that in mind. It's not about the address on the card, it's about when the address got on the card. All right. The next question I have here is, if your sister is a permanent resident and wants to file for you and you overstayed your visa, what's the first step they need to take? Right? You are in the US, you came in with a visa, you overstayed your visa, your, your sister is a permanent resident and is willing to file for you. What is the first step? Well, the first step, right? The first step is that your sister needs to become a US citizen. All right. Because again, a permanent resident cannot file for siblings. So that's why I said your sister needs to become a US citizen. Because if they are not US citizens, they can't even, like, this question doesn't even apply until they become a US citizen. Now, let's switch up the question, right? Because let's switch up the question and say, if your sister is a US citizen and they want to file for you and you overstayed your visa, what is the first thing to do? Right? So it's a different question from the first one. This one is one where there's actually possibility of a filing taking place. So if your sister is a US citizen, you're in the US, already overstayed your visa, and they want to file for you. Well, the first step is you need to understand that you will need a waiver for being an overstay, right? When you overstay your visa, that's a problem when you try to get a green card. But then you need to make sure that you actually have a way to get the waiver, right? So, ways to get a waiver: you have to have a US citizen or permanent resident spouse or parent. So if your sister files for your parents and your parents become permanent residents, now you have a way to get a waiver. So the first thing you need to think about is, do you have a way of getting a waiver? Because if you don't, then even if your sister files for you and you wait the 13 to 14 years for a visa to become available, once that visa is available, if you do not have a way of getting a waiver, it doesn't matter. So first thing you need to think about is there a way for me to potentially get a waiver by either having a US citizen, permanent resident, parent, or spouse? Okay, so that's the first thing you need to consider before you even start filing. All right. Now, understanding that this can change over time, right? The petitions by siblings are taking, like I said, 13 to 14 years. So things can really drastically change between now and 13 years from now. In your life personally, with your parents. So if, let's say, right now your parents are happy in their home country, they don't really want to come to the US, and your sister goes ahead and files for you, with the hopes that later on there will be some form of understanding or some way for you to get the waiver, right? If, 5 years from now, 6 years from now, your mom is like, you know what? I think I'm okay coming to the US and being with, my kids and grandkids and all of that. Well, then your sister files for your parent. They come to the US. Now you have someone to base your waiver on. Okay. So it's so important that you consider the waiver aspect of it before you even get started. All right, so we have a live question. So I'll go ahead and get on that one first. So the question is, my dad came to the US with a visiting visa last week, and I would like to change his status. Will it be okay to start now or wait later? What forms will I use to file for him? All right, so it depends, right? When he came to the US, did he have any intention of staying here permanently, or did something change in the last week that he's been here, right? When you're coming on a visiting visa, you're basically saying, yeah, I'm here, I just want to come and visit and go back. I have no intentions of staying here permanently. So if there's any immigrant intent, right? If there's anything from when he was coming that shows that he was actually planning on staying here permanently, you may want to wait. Right? But if there's something that changed in the last week that he was here, for example, he got here, he may get, if he got sick or something happens in between that's like, okay, you know what? I'd rather you stay here than go back home. And now that I want you to stay here, I have to get you status because you can't just be in the US without status. Then there's no reason to wait, right? So just be careful of that immigrant intent. What forms will you use? You would need an I-130, right? You will need the green card application. And like I always say, you should include a work authorization and a travel permit in case, during the time frame, those are approved first before the green card and he wants to travel. With the travel permit approved, he would be able to leave the US. Without a travel permit, he cannot leave the US. So keep that in mind. So what forms will you need to file for your dad that came to the US with a visiting visa and now wants to stay, and you as a US citizen can file for him? You will need an I-130, an I-485, and the affidavit of support form, which is the I-864. And then if you want to, this is optional, you can also include the work authorization and travel permits, which are the I-765 and the I-131. All right. So I hope that answers your question. Let's see. More questions. My mouse is choosing not to work right now. All right. So my question, after your biometrics, how long after you will hear from USCIS? Thank you. Okay. So it depends on what you're filing for. Right. So if you're filing for a green card application and you just did your biometrics, just know now they can start processing your application. Right. So when you file your application, USCIS cannot actually start processing, if you file the work authorization with it, they can't actually start processing those until you do your biometrics because they need to do a background check first. That's the purpose of the biometrics. So once they do that, that's when they actually start processing your application, deciding whether to approve your work authorization now or, how long that's going to take, all of that stuff. So this is just the first step. All right. This is just the first step. And there's going to be quiet time between now and the next step. Okay. So don't think, a month from now, 2 months from now, if you don't hear anything from USCIS, it just means they're processing your case. Right. It doesn't mean that anything is wrong. It's just the biometrics is literally the first step that they take in processing your case. Right. So when they get your application, they put it in line to get an appointment for the biometrics. You do your biometrics. then they can start the next step of putting it in line to get in front of an officer that's going to just review it and decide what the next thing to do is, whether to schedule an appointment for you to have an interview, whether to approve it, all those things. Okay, so this is just the first step. Don't freak out if you're like, 6 months down the line and nothing else has come from USCIS. It's just, this is just the first step. Okay, but congratulations to you. You have taken the steps. Okay, you are on your way. So don't freak out. All right. So let me make sure I'm seeing all the questions. All right. So if he has intentions of staying here permanently, then the question becomes, did he have that intention before he came to the US or while he was in the US? Because with a visiting visa, you cannot have an intention of staying in the US permanently when you get the visa or when you're coming into the US with the visiting visa. So that's what I was talking about with the immigrant intent. If you have immigrant intent, you are not allowed to get a temporary visa, right? Especially a visiting visa, because that is saying that you're just coming here for a short while and you're going to go home. Okay. So if you have any other questions, please feel free to put them in the comments. I am happy to respond to them. So while I'm waiting for that, let's move on to the next question that I have here. So this question says, I got my I-551 stamp in 2022 and it's expired now. And my foreign passport is expired too. They sent my green card with an error. I have to send them back. How can I get an I-551 stamp? Well, if you watch my videos on the I-551 stamp, it's basically telling you that you need, it takes the place of your green card, right? If you don't have the physical card, if the physical card has expired, you can get and you're already filed to renew it or replace it. The I-551 stamp allows you to have proof that you are a permanent resident, understanding that it does not, because your card has expired or you had to send it back because there was a mistake on it, does not change the fact that you are a permanent resident. All it does is you don't have proof of it, right? You're a permanent resident, but you don't have proof of your permanent residency. All right. So that's all that is. If you want the stamp, so even if your foreign passport has expired, even if the card, the stamp that you previously had has expired, what you need to do is contact USCIS, their customer service line, or on their website, they have a chat feature called Emma, and you can ask for an ADIT stamp, right? An ADIT stamp is what the I-551 is, right? Is basically gives you a stamp that you will be able to use to, it's a stamp that you need to be able to, you get to use to show that you are a permanent resident. So you can use it to get your license, to travel, all the things that you can do with your actual permanent residency card. The I-551 stamp will take care of. You just need to make sure that you go ahead and get that stamp as soon as possible by contacting USCIS and asking for an ADIT appointment and explaining why you need the appointment. Okay. So that's how you would get an ADIT stamp if the one you already have is expired or your green card has already expired. All right. So next question is, when you file your I-485, like what time you usually hear from USCIS with a receipt? So basically, when you file your I-485, which is the green card application, and the first thing that comes in is your receipt notice. So it's basically USCIS saying, we received your application, we received your fees, we have accepted your application. Now we're going to start processing it. That's what the receipt notice does. It's basically saying we've received it. Thank you. That's it. So how long does that take? USCIS, it can take anywhere between 2 months and a month, 2 weeks, 2 weeks to a month. But if you are filing, so for the green card application, it's typically 2 weeks to a month. But for people that are filing VAWA applications, asylum applications, just know it can take longer than that. So don't freak out. Just make sure that you track your package, right? Whatever you send to USCIS, make sure you have tracking on it to make sure it was actually delivered, okay? Because that's the first step. If you send it without any tracking, you have no way to prove when you sent it, how you sent it, if they received it, if they didn't receive it. So just make sure you put that tracking, and you can have some peace of mind that it was delivered, right? And you know you're just waiting for a response from them, okay? Because if you can't even tell if it was delivered or not, you have multiple anxieties going on, okay? So to relieve yourself of some of that anxiety, get tracking with anything you send to USCIS. All right. So what form do you file for your parents who overstay for 23 years? So if they came in with a visa and they overstayed their visa, even if it's 23 years, as long as you are a US citizen, you can file for them, and you would do an I-130 and an I-485 with the affidavit of support, which is the I-864. And of course, I always say, add the work authorization and the travel permit, the I-765 and the I-131. All right. So if your parents overstayed their visa, those are the forms you will need. All right. So this is a bit of a long one. So I visited, yeah. Sometimes I can talk well. I visited America 3 times. The last time I stayed 6 months, but I was late for my return because I got sick and went to the hospital twice. The number of days of delay is 7 days. I have my hospital papers with me. If I want to visit America again, can there be a problem with the immigration officer at the airport and send me back to my country? Please help if you are available to answer. So basically, this person came to the US. They were only supposed to stay 6 months, but they ended up staying 7 days past the 6-month mark. And they want to know, will this affect them trying to come back to the US? The short answer is yes, right? US immigration knows when you came in and when you left. And when you overstay, the officer has the right to ask you questions about the overstay. You will most likely be put on secondary inspection. This is normal process. So yes, there can be a problem where the officer will try to stop you from entering the US. So it's really up to the officer at the airport to decide whether to let you in or not. If they choose not to let you in, they'll just have you go back to your home country. If they choose to let you come in, they may limit how much time you can spend here. So if the last time you came in, it was 6 months and you overstayed by 7 days, they may limit you to like a month, right? Or a certain number of days, depending on what you say you're coming here for. But it is, ultimately up to the officer to make that final decision. But any overstay, even if it's a 1-day overstay, can affect your ability to come back with that visiting visa. Okay. And some officers will even take a step further and cancel your visa at the airport. So you would then need to apply for a brand new visa. So keep that in mind. And then the next question is about marriage-based green cards and the interview. So this person is asking, can the immigration officer separate me from my husband, and can that hurt our marriage-based green card case? So can they separate you from your husband during the interview? Yes. Will they? It depends. right? It really depends on the officer and how they want to conduct the interview, right? So they may have the US citizen come in first, ask them questions, or they may have the non-US citizen come in first and ask them questions, and then have you come in and, see if your answers match. Okay. So they're not really separating you and like putting you in separate rooms, especially for the first interview. We're just talking first interview. If they have to do additional interviews, the process is going to be different. But for your first interview, the officer has the option of calling one of you in first and then calling the other person in. They can decide to have both of you in the room at the same time. It's really up to the officer. Now, the second part of the question is, can being separated for the interview hurt your case? It only hurts your case if your answers do not match. Okay, being separated from your spouse when you're interviewed for your marriage-based green card case only hurts your case if your answers to the officer's questions do not match. Right? So if your answers match, it does not hurt your case. Right? But if your answers do not match, it hurts your case, because then the officer is going to question whether your marriage is real if you two can't even answer the basic questions of like, where did you meet, how did you, where did you go on your first date, what did you do last weekend. When you can't answer those questions, the officer is going to have an issue approving your case, because now they have doubts. Now they have doubts of whether your marriage is real or not. So the separating you for the interview by itself is not a problem. It's your answers to the officer's questions that is the problem. And for me, I always prepare my clients to be separated, because once they already know that, oh, the officer is going to call me in first and then call my husband in second, that anxiety goes away. Because there's people that go in there thinking, oh, they're going to call us in at the same time. And then when they call them in separately, their anxiety level shoots through the roof. So I always prepare my clients to expect to be separated. And then when they're not, they're like, whew, I thought that was going to be harder. I'm like, but don't you feel better? Because you were prepared for it to be that heightened interview process. So just know, separation by itself, not a problem. Getting your questions wrong, getting your answers, completely off from each other, that is the problem. All right. So next question. All right. This one is a bit of a long one as well, so bear with me while I read this. Can you do this if you have a green card, right? I am a US citizen. I applied for my sister in 2007, and I got approval in 2008. Now waiting for her immigrant visa. She lives in India. When I originally applied for her with family, it was her husband, and 2 minor kids. But her husband passed away, and she is thinking of remarrying. In this scenario, how can we update NVC, the National Visa Center? Also, will it be better if she remarries now or after she gets her green card? Okay, so multiple layers. So this is a sister filing for a sister. And when the sister filed, the sister that lived in India had a husband, 2 kids, great. But while they're waiting for a visa to become available, for them to start the National Visa Center stage, the husband passes away. What do you do? Now, you can remarry, because at the National Visa Center stage, they haven't started the DS-260. They haven't started the visa application part of the process. So they can choose to get married. So the sister can choose to get married. And then once they're able to start the DS-260, the visa application, update NVC, the National Visa Center, with, oh, my ex-husband passed away. I am now remarried. And they do that by showing the death certificate of the first husband and the marriage certificate with the current husband. And that way, the husband that gets to come with you to the US and gets to apply for a visa with you at the same time is your current husband, right? So you can do that, which to me is a simpler process, or you can do the longer, drawn out process of, getting to the US, getting your green card, filing, waiting several years for that process to complete, and then the husband coming. All right. So in this situation, this is actually great timing because you're able to go ahead and file, go ahead and have your new husband join you in the US at the same time without having to delay with filing a petition and all of that. They can just be added onto your process. All right. And then, the next question, the final question that I have here is, when you're petitioning for your visa overstay parents, can you do it if you have a green card? The short answer to this is no, because, right, if your parents overstay their visa, a green card holder cannot file for a parent. So that's number one, right? A green card holder cannot file for a parent. You have to go ahead and become a US citizen. And once you become a US citizen, you can just go ahead and file a normal petition, an I-130, an I-485, with the affidavit of support and all the additional forms you may want to add, just normal, but you have to be a US citizen. So for visa overstay parents, if your parents are back home and you want to file for them, just know if you're currently a green card holder, you must become a US citizen before you can file for them, because only US citizens can file for their parents. Okay, so I hope that answers that question. As always, if you have questions, put them in the comments, because it really does help other people to hear your questions, they may not even think to ask some of these questions. So it's always good when I see people asking questions, because we can all learn together. All right. Okay, so final thing from Faye. Should I still file for change of status even though he made his mind up to stay here in the US because he's I would suggest just reaching out for a strategy session so that we can discuss that. Again, YouTube is a public forum, so when you're putting information here, just be careful on what information you're putting out there in the world. But definitely schedule a strategy session with me just so we can discuss your options. Okay. All right. So that is all the questions I see here, and those are all the questions I have on my list. If you have any questions, put them in the comments. If you want to join my amazing community of informed immigrants, go ahead and subscribe, like, share this video. And as always, if you want to know if you qualify or if a family member qualifies for a green card citizenship, feel free to reach out for a strategy session by going to my website, lilylegal.com, or by calling my office at 508-443-1788. Thank you so much for joining me today. I thought this was going to be a shorter video, but ended up being longer than I expected. But as always, I love answering these questions. I love it when you all engage with me and ask me questions. So please continue to do that. And for those that stuck around to this end and still don't know who I am attorney Lilian Chukura. I'm the owner of Lily Legal, where we help our clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. Thank you so much.